Welcome to another episode of the Criminal Law Department Presents podcast, a production of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Every 2 weeks, we release a new episode. Today, we're going to have a conversation about a recent opinion from the Court of Appeals for the Armed Forces. Please note that these episodes may contain facts and circumstances surrounding criminal trials. Listener discretion is advised.
All rise! Hear ye, hear ye, hear ye. The Honorable United States Court of Appeals of the Armed Forces is now open and in session. God save the United States of America and this honorable.
Welcome back to another edition of CAAF Chats presented by the Criminal Law Department. We have a very special episode for you today because we are going to talk about not one, not two, but 3 cases. And to make it more fun, there's not one, not two, not 3, but 4 of the department members here to talk about these 3 cases. We have the chair, Lieutenant Colonel Mike Scoletti. Sir, welcome aboard.
Good to be here, James.
We have the portfolio holder for these specific cases, Major Alex Altimus. Good morning, Alex.
Good morning, James.
And we have the infamous Major Andrew Britt. Andrew, how are we doing today?
Good, James. How are you?
I'm all well. Thank you for asking. All right. So on 23 January 2026, CAAF hit us with 3 cases, Moore, Hennessy, and Surjak. These 3 decisions from the CAAF address one of the more recent and most litigated issues in military justice: what exactly the government must prove to establish sexual assault without consent under Article 120B2 Alpha. So, Alex, why don't you take us away?
Yes, thanks, James. The conversation really began with United States versus Mendoza. And in that decision that CAAF first made, they found that Article 120 contains distinct offenses with different theories of liability. If you remember, Mendoza involved charging without consent and providing potentially only evidence to prove incapacitation. And so in the Mendoza case, what I think is where we end up with these 3 cases is in it, CAAF stated that Article 120 Bravo 2 Alpha UCMJ, which is without consent, criminalizes engaging in a sexual act with a person capable of consenting who did not consent. And Article 120 Bravo 3 Alpha, which criminalizes engaging in a sexual act with a person who is incapable of consenting. This remark seems to have created some confusion within the CCAs.
So what's boiled down in the simplest terms, we'll go to Colonel Scoletti here. What is the main issue that we're fighting about here continually?
So the main issue that we're looking at here is the issue of surplusage and how you've put the evidence on at trial. So whether or not you're meeting the elements of without consent with the evidence that you put on at trial. So when you think about Mendoza, and they flat out say it again here and more, that you cannot rely solely on someone's inability to consent to prove lack of consent, that you have to find some other facts to support that.
Okay. And so, Alex, what are we looking at with these 3 cases now?
So in Moore, Hennessy, and Surjak, the AFCA set aside the convictions for sexual assault without consent. In 2 cases, and then in Moore, AFCA found that the evidence presented was either factually or legally insufficient. And so AFCA, based on the finding in Mendoza, found that the government failed to put on evidence that the victim was capable of consenting at the time of the sexual assault, but did not consent, essentially arguing that there has been a 3rd element that's added to Article 120 Bravo 2 Alpha, that in addition to it being a sexual act that occurred on another person, it did so without that person's consent, the government must now also prove that the person was capable at the time the sexual act was occurring and did not consent.
Part of the issue for these 3 cases is that they were decided prior to the court's decision in Casillas. And part of the reason why the court is reversing AFCA here in these 3 cases, or at least in 2 of them, is because of the principle that was established in Casillas, and that examines what evidence should be considered or must be considered in determining a sexual assault without consent. When you're distinguishing between legal sufficiency and factual sufficiency, what the court is doing is different for those 2 things. So Moore was the only case that dealt with legal sufficiency, and there CAAF gets to actually review legal sufficiency. So what they're doing is they're taking the principles that they've determined are required to be considered, so essentially what evidence must be considered, and they're looking to see if there was some evidence in the light most favorable to the government to see if there was enough there for a rational trier of fact to determine that the evidence is beyond a reasonable doubt to sustain a conviction. Factual sufficiency is different. CAAF isn't piercing down and doing its own factual sufficiency review. Only the CCA can do that. But what CAAF can do is they can examine whether or not the CCAs are applying the correct legal principles. And here, for all three cases, CAAF found that the CCAs were not following the correct legal principles. A bit of an oddity, again, because one of those principles comes from Casillas, and that wasn't decided yet. And then Moore also establishes a new principle. And they're also saying that the CCA didn't apply that correct principle, even though it wasn't a principle at the time.
That's great. And I think one of the issues we have here is it's a mix of standard of review and legal principles that's getting jumbled up in these opinions that causes the field such angst, right? CAAF is saying you need to do Article 66 review again because of what we established in Casillas. And here, people may say, oh, this is good to go, but this is appellate stuff working its way through the system.
I'll just add, James, that these decisions don't sustain the convictions. They're not saying that these convictions were right. CAAF is sending these cases back to AFCA to redo their math on factual sufficiency. That's it. AFCA could come out either way so long as they apply the correct legal principles.
I think that's important, Britt. I don't think the field should read these and say, okay, I can charge it this way. This one survived. I think it's going back to review. And I think some of these cases may be stronger to survive another factual sufficiency review. But I think it's important for the field that these three, that CAAF is not saying, I find these factually sufficient. CAAF is just saying, apply these principles. And they say over and over in all three of these decisions that CAAF is not saying these are good or not saying they're bad, just saying you need to apply the principles that we have set out and more, which brings us to the three legal principles.
Yes, let's talk about those principles, Alex.
So I can begin with the first one, which is what we get from Mendoza, right? And this is really the takeaway. The first principle that CAAF identifies in Moore is the government cannot prove the absence of consent by merely establishing the victim was incapable of consenting at the time of the sex act. That applies to incapacitation cases. That applies to when you're asleep, right? The MCM is pretty clear that a sleeping person cannot consent. They're saying that you cannot prove the absence of consent by merely proving that the victim was asleep. There needs to be more, and that is doubled down in Casillas and in Mendoza.
And let's remind the field again, we're talking about a statutory definition passed by Congress, which has all of these definitions in the same paragraph, that if you look at the military judge's bench book, they, in every case, whether it's incapacitation or not, reads the same definition of consent that's found within the MCM. So it gets more confusing a little bit there. But what's your second principle?
The second principle is that if a rational trier of fact could find from the evidence both that the victim did not consent before falling asleep and that the sexual act subsequently occurred while the victim was asleep, the evidence is legally sufficient. This principle was first announced in Moore, and the court finds it's grounded in logic and consistent with 120 Gulf 7 Charlie, which is what you were just going to the definition of consent, which mandates consideration of all surrounding circumstances to determine whether a person gave consent.
And Colonel Scully, sir, could you please give us an example of that specific scenario that Alex just laid out?
A factual scenario would be like you're throughout a night, somebody has a party and they're all talking to each other and they're like, nah, I'm not interested. And there's some separation between the two, probably some expression of lack of consent that you'd get either through verbal or nonverbal signals to the accused. And then that person falls asleep and then the accused commits a sexual act on them while they're sleeping at that point. I think that's essentially what CAAF is getting at there, is that if it's charged without consent, you can establish that without consent before they lose capacity, is essentially what they're trying to say.
I think, James, that's the exact scenario in Moore, right? In Moore, they have no sexual or romantic relationship. She falls asleep on his couch and wakes up to being penetrated by him. And essentially that there had been no consent prior to, there had been no relationship prior to, and the sexual assault or sexual act occurred while she was asleep.
And this principle, I think, is the one that's doing the most clarity for the field. It's saying that the period in time in which a victim has capacity and actually does render non-consent does not need to be contemporaneous with the sex act itself.
Britt, walk us through that a little bit more, because I think that's important.
So the confusing language comes from Mendoza, which is that the sexual assault without consent criminalizes engaging in a sex act with a person capable of consenting who did not consent. And Article 120 Bravo 3 Alpha criminalizes engaging in a sex act with a person who is incapable of consenting. So I think AFCA took this to mean that the capacity to have consent had to be contemporaneous with the sex act that occurred. And even though CAAF maintains the language from Mendoza, they do drop a footnote in the opinion to clarify that that language does not mean that the sex act and the capacity need to be contemporaneous. As long as prior to the sex act, there is a time in which the victim has capacity, expresses non-consent, and maintains that non-consent through the point of capacity, then you can use that essentially pre-rendered non-consent to still find that the sex act during the period of incapacity was without consent.
I'm going to pitch this back to you, Alex. How do you charge that?
I think you can charge it both ways. I think you can charge multiple theories because I think there are potentially multiple offenses there, right? I think when the sex acts occurred and there was no pre-rendered consent at the time and that person is sleeping or incapacitated and incapable of consenting, you have without consent. I think you also have potentially incapacitation and sleep, depending. And I think that's kind of where all three of these cases are charged without consent. And all three of these cases have different levels of other theories of liability. And so I think when we get to the third principle, it kind of ties back into that of what should be considered.
And so what are your thoughts, Colonel Sletty, sir, on charging this with exigencies of proof and then once findings come back, conditionally dismiss one of the specs?
That's why in my example, so in the facts in Moore are a little more blurry. Like if there's an express, very clear non-consent, like I don't want to have sex with you tonight, period. Stay on other side of room kind of thing. And then it gets really, really easy to do that charging decision. There is a tendency, especially among like advocacy trainings, to shy away from putting multiple theories on a charge sheet. What they're trying to tell us in these cases is like sometimes the world is a murky place and you've got to charge both things because you don't always know exactly how a witness is going to testify. You don't know exactly how the facts are going to come out and whether or not you're going to be in a world where they've lost capacity with it still being an unanswered question as to consent, or if they clearly maintain a lack of consent up to the point of incapacitation.
And James, we'll talk about it more during the takeaways, but I think the court is providing a framework. They're not saying it explicitly, but we might not even be in an exigency of proof charging situation. We might just be in a distinct crimes involving one sex act. So consider this scenario where a victim, while having capacity, says to an accused, I don't want to have sex. She falls asleep. The accused then commits a sexual act on her while she's asleep. Based on the Moore second principle, you have sexual assault without consent because you have this pre-rendered non-consent. You also have sexual assault while asleep. While they might be affected by unreasonable multiplication of charges, you don't have a multiplicity issue there. So you actually have two distinct crimes occurring, even though you have one sexual act.
So let's move on to new principles. Alex, what do we got for us next?
So the final third principle is that evidence may be legally sufficient to prove the without consent element if the evidence shows that the victim was asleep when the sexual act began, but awoke before the sexual act was complete, and while awake, did not consent to the ongoing sexual act.
And that goes back to your point you just made, Andrew, right? Is crime one, asleep, crime two, without consent when the victim wakes up.
Or even the reverse, where it can be without consent when the victim falls asleep because she did not render consent prior to falling asleep. But I think it also could be when she wakes up and says no, and kind of like in Casillas, where the sex act keeps occurring, you could have without consent there. But then the question of capacity potentially could be a question there where prior to the sexual act occurring, there was no consent given.
I think for principle 3, the important part is that the person regains capacity while the sex act is occurring and then manifests non-consent and expresses it to the accused in that moment. So looking at principle 2 versus principle 3, it's a question of whether it occurs prior to the sexual act and prior to the incapacity, which would be principle 2. And then principle 3 would be whether the non-consent occurs during the course of the sexual act, but before it's complete. Either way, principle 2 or principle 3 gets you there for checking the element of non-consent for a sexual assault non-consent offense. But I think neither of those actually get to the question as to whether or not you can separately charge in a sleep or otherwise incapacitated offense.
Well, Andrew, so in that scenario where she wakes up in the middle of it but was incapacitated in terms of intoxication, right? Like waking up from a sleep and you were just asleep and waking up, you are capable again. Do you think at that point where the government would have to show evidence that she was capable when she woke up? Or do you think not so much?
Alex, I think this kind of gets to the big question as to whether or not the government has an obligation to prove capacity,
Agreed.
whether or not that is some sort of like judicially created element. I don't know whether these cases answer the mail on that question, but I do think that if we're talking about a principle 3, Casillas principle scenario, when the victim regains consciousness, whether as a result of intoxication and then kind of comes to, or whether she wakes back up after having been asleep, she would have to have capacity in that moment in order to effectively express non-consent.
I think that you just made me think of an important point we may have skipped over on the second principle, is that it also applies to intoxication, not just asleep. It's easier to see a scenario in the third principle when someone wakes up and a sex act is being done to them, and they can easily manifest that non-consent. It's not as easy to conceive of that in an intoxication scenario. But the second principle is thoroughly discussed in Moore, where it does apply to an intoxication scenario.
And I think we have increased confusion too, sir, and Hennessy is probably a good example of this, where we know that the victim is in some type of diminished capacity, but we also know that alcohol is involved. But what's unclear, at least from CAAF's decision, is whether the evidence was going to show that they were incapable of consenting due to alcohol, or whether the victim was asleep as a result of a combination of alcohol and otherwise being tired. So it makes it unclear, too, when you have alcohol in the mix of someone who may also be sleeping, as to whether or not it's a sleep theory or whether it's an intox theory.
Yes.
Clear as mud.
Yes. So I think it's helpful if we go through just kind of the facts of the 3 cases.
Yes.
I think more is where we get these principles from, which we just discussed. But I think more facts are a little less murky.
And I think it's, for the field out there listening, it was important for us to talk about the foundational legal principles for these 3 cases and now overlay them with the facts of these 3 individual cases to show you how the principles we just discussed are being implemented within these 3 cases. So a little reverse order here, but something that was intentional on our part. So walk us through the first set of facts, Alex.
So in Moore and the victim were in her dorm room and she fell asleep on the couch. She may have put her feet near him. It was a small couch. She had her feet on the couch and they were under him, and then he put them over her. And that is really the extent of any sort of touching. The victim testified on direct that there was no romantic relationship. They had always been platonic, and they very rarely hung out, and that there was no cuddling, no kissing, no sexual advances, and she didn't take the foot movement to be anything other than just making it more comfortable on this tiny couch in her dorm room. And she woke up to feeling more inside of her body, is what she testified to. She fell asleep fully clothed, but awoke to pieces of her clothing removed, and Moore was digitally penetrating her. She immediately yelled at him, asking him what the fuck he was doing. He replied with, "You're right, you're right." She immediately kicked him out and reported to numerous friends. He was charged and convicted of sexual assault without consent.
And which principle are we looking at now of the 3 we went over?
So Moore is where the principles all get announced and ordered, and I think Moore actually looks at all 3 principles. So one consideration is that we always have to look at principle 1. And in principle 1, I think the word that's doing most of the work is merely. So you're not merely relying upon the incapacitation to prove the non-consent. So we start with that principle, and then we are now looking at, well, what other evidence do we have? Which then moves us on to principle 2, which allows us to now look at pre-incapacity expressions of non-consent that were then maintained through the incapacity.
Okay. And so what's the next domino to fall here? Alex, you want us to walk through the application of principle 2 factually to Moore?
Yes. And so it's interesting because they talk through an analysis, but they find it consistent with Mendoza, even though this is not an incapacitation case. This isn't a sleep case. That the government can offer evidence of an AV's sleep or alleged victim's sleep to prove the absence of consent, but it cannot prove the absence of consent only with the evidence that the victim was asleep. And so in this case, they're using the fact that there was no relationship prior, there was no consent given prior to her falling asleep, and that the sex act occurred. And so they're finding the without consent occurring prior to her falling asleep.
And then in principle 3, we're applying this theory from Casillas, which is that you can look to where an ongoing sexual act is occurring and the victim regains capacity in the scenario she wakes up while it's occurring, and whether or not she's expressing non-consent prior to the sexual act completing.
CAAF does discuss specifically that in principle 3, that the victim in this case remembers the fingers being removed as she awoke. So, and then that is when she says, what are you doing? And so that's where they get into it, is like I think they're hinting at that could be a fact that could get you there, maybe. Because they don't want to express an opinion over factual sufficiency as they send it down. But it does feel that they could get there that way.
And Moore is the only case that argued legal sufficiency as well.
An important piece of this, as we talk about kind of the procedural posture of it, CAAF can answer the legal sufficiency question.
Correct.
CAAF has concluded, in light of these principles, the evidence was legally sufficient. The only thing that goes back down to AFCA on remand is for them to redo their factual sufficiency map.
With the overlay that they were given just by CAAF.
Yes, and then also consideration of any other legal issues that they might have mooted as a result of their original decision.
This is just all fascinating. Okay, so Moore's
Trial.
So so we've done Moore. Moore was the first case to come out. What was the second case that they dropped?
So they dropped them on all at the same time.
What?
So I think we should go through Hennessy next
Yes.
before Surjack. And so Hennessy is a little less clear. Hennessy was charged with committing a sexual assault upon KE without her consent. The victim testified she met him online. They exchanged messages online and decided to spend some time with him in his dorm room. While he was there, he attempted to kiss her a bunch of times. She said no thank you and left. He then texted her for apologizing for moving too fast and asking if they could start over. They agreed to meet at a club, and then KE became intoxicated at that club. He attempted a few times to touch her. She denied that at the club, but then became increasingly intoxicated to the point where he gave her a piggyback ride. She has no memory of that night. Her next memory is waking up in his bed while he penetrated her vulva with his penis. She decided to fake being asleep to get him to stop. She closed her eyes and turned her head to face the wall. She testified that the accused called her name and shook her to try to get her to respond. And when she did not, he stopped and went to the bathroom. She immediately reported when he went to the bathroom. This case is interesting. Defense calls an expert forensic talks to testify that she could potentially have been in a alcohol blackout and that her ability to form and retain memories could have been compromised, but that being in a blackout does not necessarily mean that she was too intoxicated to engage.
Sir, you have a thought.
I always have thoughts, James. Okay, so I think that this is what I was getting at with the second principle being interesting with regard to intoxication. You have a lot of really good expressions of non-consent. Your place or mine. How about you go to your place and I go to my place, is what the victim is quoted as saying in Hennessy. So you have a lot of really clear expressions of non-consent, but then you have this blackout period that creates a bunch of question marks. The second principle gets a little interesting with its application to intoxication or incapacitation cases.
Any additional comments on Hennessy?
I thought it was interesting that AFCA originally upheld the legal and factual sufficiency, but then following decision in Mendoza, they changed their minds. And so I find that interesting. And so AFCA found the evidence factually insufficient because there were significant questions they felt left open in their mind of whether or not they could find, or whether or not a reasonable fact finder could find that she was capable of consenting based on her intoxication, her capacity.
And let's just do a reach back with, I believe it was the Sager opinion that really talks about
Surplusage?
Thank you. That
I thought about that too.
that the Congress doesn't double up on statutes being passed. And so you have asleep, unconscious, or otherwise unaware, or too incapacitated are all separate theories of criminal liability for an accused. And you see that kind of playing out with some of these cases as well, as without consent is a different criminal liability than too intoxicated, asleep, or unconscious, or otherwise unaware. Andrew, I think you got a pretty good thought on Hennessy and its application of the principles.
Where CAAF finds that AFCA did not apply correct legal principles is based upon the third legal principle that was announced in Moore, which has to do with where the victim wakes up during the course of the sexual assault. So in this case, the victim does wake up, or at least she testifies that she wakes up, and at that point she responds to the sexual act occurring upon her by pretending to sleep at that point in time. And potentially a rational finder of fact could find that to be an expression of non-consent at the time. I have a real issue with how, if somebody is asleep and accused is committing a sexual act upon this person, that person wakes up in their mind and then continues to pretend to be asleep, how the situation has then changed for the accused, or how there's any expression or knowledge or information that is being then given to the accused in that moment.
Well, don't you think the fact that he had to shake her, and because the posture had changed, that she had kind of pushed her, closed her eyes and turned her head, and he was trying to wake her up, shows that he realized there had been a change in demeanor, that she was now asleep. Maybe she was not doing that while she was actually asleep.
This gets to a deeper question then when we talk about, well, the expression of non-consent has to occur at a point in time where the victim has capacity.
Right.
Does the accused need to know that the victim has capacity at the time in which they're expressing non-consent?
I mean, even further, does the victim have the capacity at that point?
And the bigger question that all three of these cases do not address, and I think they maybe discuss it at one point in a footnote, is what are the implications on due process? How does this impact the ability of the accused to mount a defense? So each one of these offenses has a subtly different mistake of fact defense that they could lodge.
And I believe it's in the footnote. It might only be in Moore. CAAF notes that AFCA did not rely upon a due process issue, so they're not reviewing a due process issue in this case.
So let's take Hennessy, for example. When she's asleep and then wakes up and continues to pretend to be asleep, the issue that you were discussing earlier, had they charged asleep or otherwise unaware, the crime is complete there because the mistake of fact defense would have been like, does he actually know that she's asleep, right? Something along that.
Well, the mistake of fact is not mistake of fact as to consent. It's mistake of fact as to her ability to consent.
Well, he should have known, or reasonably should have known, whether
That-
she was asleep or not.
Yes.
Exactly. So, but then it shifts. That mistake of fact defense shifts when she wakes up, and now your mistake of fact as to consent, and you don't have any communication occurring. Then you get into a wholly different approach to the case. So that's the question mark that we still have out there about how this implicates due process.
And factually, you can infer from the fact that he tried to wake her up after she was playing sleep that he perceived that she was in some way participatory.
Something had
At
shifted.
least was awake at the time. Something had shifted.
Yes.
So,
Is that a reasonable should have known?
but should that mistake of fact defense question go deeper and require that the government establish who has the burden of mistake of fact?
The defense.
Well, no.
Well, yes, they have to raise an honest and reasonable mistake of fact as to consent.
The evidence has to raise it, and then
Yes.
the government must disprove it beyond a reasonable doubt.
Yes.
But in light of Mendoza now, does mistake of fact include a reasonable belief that the victim had capacity? Because it sounds like her playing asleep, they should have charged him with asleep,
Agreed.
not without consent.
But I think the confusing part now is she did have capacity by her own admission.
And
She was awake.
but
Not when it began.
Not when it began. So that goes back to the do I have two crimes here, which I think you do.
I think you do.
I think
And the
you
third
charge
principle,
both.
remember, the third principle is contemplating the sex act began while you were incapable, right? You were asleep or intoxicated, and then ongoing when you awoke, right? And so she awakes and comes to and decides to play dead, essentially, play asleep, and he notices that shift, where are we now? Are we still in without consent?
And I think that's a factual question for the jury, or for the panel, excuse me, or the fact finder to make that determination. Because if he's shaking her to say, oh, something's changed, that means that he would assume that she was awake and was consenting to it. So you have two layers then. If you're the government, you have to prove that, one, she was in fact not consenting. And then two, if she was not in fact consenting, did he have an honest and reasonable mistake of fact to that belief? Because remember, the mistake of fact defense doesn't say the crime wasn't committed. It's just a legal justification for what he did.
And remember, mistake of fact as to consent only applies in without consent cases.
Correct.
It does not apply in the other two theories.
But it's the new or reasonably new, which is supplanted. There's a...
It's baked in.
It's baked in
under Teague, but but it's baked into her capacity. And I think that goes to the shift potentially, that she had to have been doing something during the sex to make him believe that she was participating. And then when the shift happens and he has to shake her and calls her name to wake her up or to get her back to participating, that to me shows that could be baked in there. But again, they did not charge it under a incapacitated or while asleep theory, so it's not applicable.
So before we get to the takeaways here, let's go over the last case very briefly.
So the last case is Surjak. He was charged with committing a sexual act upon JM without her consent. JM testified at trial that on the night in question, she began to drink at a party. She met Surjak there. She had never spoken with him before. She continued to drink, becoming, in her own words, pretty under the influence. He was a designated driver and drove her back to her dorm. After arriving at the dorm, she began to walk to her room. He called her back, and she somehow goes to his dorm room. She lays down on his bed and falls asleep. She was fully dressed, except she had taken her shoes off when she fell asleep. She woke up. She was wearing only a jacket, and her hair was wet. She immediately went into his bathroom and locked the door. Here's where we have a tampon, where she says was lodged deeply inside of her body, and testified that she does not have sex while on her period. She then ran to her room, and she testified she does not remember having sex with him and that she did not want to have sex with him before she fell asleep. Surjak made some comments to her and his first sergeant, stating that she pressured him to have sex and she dug her nails into him during the same, documented scratches on his body. And so he was convicted of one specification of Article 120 Bravo to Alpha and one specification of Article 107 for stating he was sexually assaulted by JM. So here, AFCA, relying on the CAAF's decision in Mendoza, held the evidence was factually insufficient, mostly based on the government's failure to present evidence that she had the capacity to consent as a competent person and did not consent when the sexual act occurred.
And why does CAAF kick this one back?
So CAAF kicks back Surjak based upon principle number 2. So in this one, they say principle 3 is not at play because the victim does not awake during the course of conduct of the sexual act. So they're only looking at principle 2 and whether or not in their factual sufficiency review, the AFCA considered prior to the victim being incapacitated any expressions of non-consent that then essentially continued on during the period of incapacity.
So, Colonel Scaletti, sir, hit me with some takeaways.
Well, I think from a government perspective, the takeaway is to know your facts, like know essentially what happened. And then the biggest takeaway is to charge both. Charge all theories that can apply. And then to present all of these surrounding circumstances. I think that there's a tendency for particularly young or new counsel to go out and just say like, okay, I got the penetration, now I'm done. And not to talk about or accentuate the circumstances leading up to the event. So if you have expressions of non-consent that occur at the bar before they go back to the barracks room or whatever, that's super relevant to the factual determination at the appellate level.
Alex, what do you got for takeaways?
So I think, while it may not be super clear in these three, I think CAAF in all three of the cases consistently states that there are two elements to Article 120 Bravo to Alpha without consent, that a sexual act occurred on another person and that other person did not consent. And so in these Air Force cases, the AFCA is essentially saying there's this third element that the government must prove that the victim was capable of consenting at the moment of the act. And I don't think that CAAF necessarily says that's not true, but they over and over say that there is only two elements. And so I think that that's a takeaway for the field, that the government does not necessarily or implicitly need to prove that the victim was capable of consenting at the moment of the act. but the government must prove a lack of consent, which can occur at any time during the sexual act, to include pre-sexual act beginning.
And Andrew, you got some takeaways for us?
So in Moore, while discussing the first principle, the court, I think, signaled where practitioners at all levels should be considering the application of these principles. The court points to providency during guilty pleas. For contested cases, the court highlights RCM 917 motions and panel instructions. Then on appeal, these principles guide CCAs in their factual and legal sufficiency determination and CAAF in its legal sufficiency determination. So I think that this was helpful from the court to kind of identify the areas where these principles are being plugged in and where they need to be considered by different practitioners. Also of note, all three of these opinions are authored by Judge Maggs, and the only concurrence or dissent across any of them all come from Judge Hardy. So Judge Hardy concurs in Moore and Hennessy for the reasons he stated in Casillas, but dissents in Surjak for the reasons stated in Mendoza. The notable distinction between the resolution of these cases is Principle 2, regarding establishing non-consent through evidence occurring prior to incapacity. While not explicitly discussed by the court, Principle 2 appears to support that an accused may be committing two distinct crimes on an incapacitated victim that did not consent prior to incapacity. So, for example, if a victim expressed non-consent then fell asleep and an accused committed a sexual act on her while asleep, then the accused would be separately violating Article 120 Bravo 2A and Article 120 Bravo 2B. I suppose there's also a scenario where a victim gave consent and then fell asleep, whereupon an accused commits a sexual act upon her. In this scenario, there would only be an offense under Article 120 B2B for sexual assault while asleep. To the extent that there may be some lingering confusion from this second principle, I think it may be because it provides that a victim can pre-render non-consent, which is preserved during incapacity, but pre-rendered consent cannot be preserved during incapacity. However, I think that this oddity is clarified by keeping to the elements of the offenses and viewing them as distinct offenses. There is also a third scenario that CAAF touched on, but does not fully explain. So consider a situation where the evidence establishes that an accused and victim have never met or interacted before. The accused happens upon the victim for the first time ever while she's in a coma and commits a sexual act upon her in that moment. Is this sexual assault without consent under Article 120 Bravo 2A? So, proof that the victim and the accused never previously interacted at a time when the victim possessed capacity prior to the coma would strongly imply that the victim did not consent to the sexual act by this stranger. However, if you look at footnote 4 of Moore, Judge Maggs discusses that Article 120 Bravo 2A is not the legally appropriate offense for a victim that is persistently incapable of consenting due to a mental disease or defect or a physical disability. The court may not be contemplating the coma situation here, but contrast this to Surjak, where in applying the second principle, the court notes that a victim could manifest non-consent, quote, at any time prior to being incapacitated. To the extent that there is an unresolved question here, I think it's whether there needs to be evidence of the victim expressing non-consent to an accused while she has capacity, or whether non-consent can be implied from the lack of interaction between a victim and accused at any time prior to the sexual act.
So is that saying that you think that there potentially that the accused would have to know that she's non-consenting before her incapacity?
I think what that's suggesting, at least in the latter scenario, is that there is an insinuation that if you encounter somebody for the first time and have no interactions with them before, there's a default state of non-consent.
And there needs to be some evidence put on of the alternative, that there was some evidence of consent.
From the defense?
Mm-hmm.
No, I think this scenario comes up where the burden is always on the government, right?
Yes.
So what the government proves beyond a reasonable doubt is that the victim and the accused have never met each other before. So let's say you have the victim who came out of their coma by the time of trial, and they say, that person I've never met before in my life. I've never talked to them. I've never interacted with them. I've never seen them. And then we know through other evidence that they committed sexual assault on the person while they had the coma.
The default is there was no consent.
Yes.
I just think this brings us all the way back to what Mendoza was originally about, though, right? If you're going to let people say that I'm not consenting, and that carries into their incapacitation, then we're back to charging somebody without consent, right? And where's that due process issue go? Because if Again, they say, I'm not consenting, they become incapacitated. CAAF saying, that's without consent, good to go, right? That's part of your issue. And I just think that kind of turns Mendoza upside down again. Sir, you have thought.
Well, so in your scenario, I think that they do somewhat address this in more. They talk, well, in all three of the cases, CAAF discusses like essentially a totality test of all of the facts that are available. He says you can't, so you said merely, they use the word solely, so you can't solely rely on the incapacitation. So if we're taking your scenario, I think that you can, under the laws that they've laid out here, the principles they've laid out in these three cases, you can say, never met them before, plus incapacitation. So you're not solely relying on it. Now you're taking an additional fact, adding it to, and in all of these, CAAF continually reminds us that you can consider the fact that they lack capacity to consent in determining whether consent was given as a fact among many. And so I think in your scenario, you're going to have a lot more facts in that scenario because the creeper is doing things leading up to that are going to give you a little bit of a window into his mind. So I do think that there's that. And then going back to your point, Alex, there's basically a copy and paste job that occurs in all three of these cases where I remember when we were reading these around the conference table in our room, in our office, that I was like, why do they keep telling us what the elements are? But it's pretty clear that what they're trying to say without saying it is there's no third element, people. Come on. And
Right.
Because it says, based on this language, the government must prove two elements beyond a reasonable doubt, quote. And that same paragraph appears in applicable legal principles and in the first paragraph of the discussion and more. So all three of them have the exact same emphasis on only two elements, people.
Which just happen to be the two statutory elements that Congress passed.
Right.
James.
Right.
Oh, boy. Contribution complete. So, any final comments from anybody? This has been a longer one than usual, but if you take our 20 minutes per case times 3, we're right about on schedule.
James, so we talked a lot about takeaways for government. Do you have takeaways for defense counsel?
Make them prove the elements. Incapacitation is a big deal. So I think when you make your expert requests or you're asking your questions, you're attacking credibility of witnesses. You're not attacking some things that you're not saying that this individual did consent, did not consent. You're talking about their credibility of what they're saying on the stand and how they perceive things. And so even though you have this potential crossover of incapacitation and without consent, I think if you're a defense counsel, it's not to, obviously you go after due process issues, but then you also have a proof issue, right? If you're the government and you're trying to show that this person did not consent, well, great. Tell me where they didn't consent and prove it beyond a reasonable doubt. I think you have problems if you have a victim up there saying, well, I was in and out of consciousness. I was in and out of this. I don't remember this. I was faking asleep here, but he was shaking me. It sounds like you were consenting, potentially. And so I think don't get wrapped around the axle if you're the defense counsel about whether it's fair or unfair how the government charged it or how they're pleading it. Find a way to weaponize it against them. And by weaponizing it is the burden of proof. And then all the things that you get to talk about and all the ways of the world and natural, or whatever the instruction says that I just can't think off the top of my head, go at them with that stuff. And so you have to attack it on the legal sufficiency side, on the law side of it. That's for the military judge. That's where you attack it through instructions, the witnesses you want produced, the experts you want. But then you also have to go back to the factual determination. And if any of these cases are showing anybody, defense counsel, foot stomp, once you lose at trial, you're talking about lottery winnings by getting your case overturned. So you have to set it up legally, but then you also have to attack it factually.
So when they do a factual sufficiency review, does it impact your decision to put your client on the stand?
Absolutely. I think United States versus Nicola out there basically can turn a no into a yes, or you can infer the opposite to convict somebody. But Britt, what do you think?
Yeah, I would agree. I think defense counsel should be aware of how your client's testimony can be used to check the blocks for legal and factual sufficiency.
Which may get rid of all of these discussions on appeal. So if you say the government didn't prove their case that this person I wasn't on notice of this or that, once your client testifies, a lot of your bets are off, which is a hard decision to be making in the field and in the moment, which there can never be a right or wrong answer. You just have to make a decision and live with it. But you have to go in full eyes wide open.
Yep. So I think that defense counsel out there, what that means is practice with your accused before you put them on the stand, so you know whether this is actually helping your case to win at trial, because when you go forward to appeals, it may hurt.
Yes.
Do you think, if you were defense counsel in these cases, because James, you mentioned notice and due process, would you be asking for a bill of particulars?
I would.
Yes, absolutely. Because it's not a criminal theory per se. You're asking them.
You've charged without consent.
Yes.
Tell me what part of this is without consent. Particularly now that we see that there could be distinct crimes within the same-sex act. What one are you charging?
And I think it helps when you ask for a bill of particulars that we're talking about two separate crimes. So you want to know which crime they're talking about when they're talking about it. Is it going to be granted? Are you going to have to fight about it with a military judge? Absolutely. Because I'm the government, I'm going to say that's trial theory. I'm going to deny the bill of particulars. And then you get into, okay, what do you want the judge to consider during your motion to force the bill of particulars? Are you putting somebody on the stand? Are you putting their statement on? This gets very complicated and very messy very fast, which is why Mendoza has been back and forth several times. These cases are going back several times. And so just a little added takeaway to the field is give yourselves a little grace, stop, think, and I understand that this is very difficult. Right? We have 5 judges at the CAAF who have a legion of attorneys helping them research. They are exceptional practitioners themselves. And here we sit.
I think at the trial level, it would help a lot to be able to shape it, and more probably helps defense counsel a lot to tell the military judge in their request for a bill of particulars to the government that they want to know, is this under Principle 2? Is this under Principle 3? Is it 2 and 3 together? Or is the government really just only under Principle 1 and therefore prohibited?
Because think of a forensic psych. You ask for a forensic psych in a case. If it's intoxication, you want the forensic psych to talk about the individual retaining the ability to consent even after they're drunk or, quote, blackout drunk.
Or the ability to act and do things that would not show that they are in a blackout.
Correct. And that is a separate use of your forensic psych for the credibility in a without consent versus a affirmative element that the government has to prove that they had the inability to consent. So if I'm asking for that expert, I have to be able to articulate what I'm using that expert for. And credibility versus attacking an actual element of the offense are two separate things. And that, to your point, Britt, very important for a defense counsel for what facts they put on, what evidence they go out and seek, what witnesses they put on. So, yeah, you have to think about it all. Well, with that, I would like to thank all 3 of you for joining us today for the CAAF Chats. And as always, we're always available via phone, email, or otherwise. But please, as Colonel Seagraves would say, smash and subscribe. And we will see you next time. Thank you, everybody.
Thank you.
Thanks.
Thanks for joining us today for another episode of the Criminal Law Department Presents podcast. If anything you heard sparked a thought, we'd love to connect with you. Your comments help us create better future content for the field or the fleet. Reach out to us on Facebook or Instagram. The information can be found in the show notes for today's episode. The views expressed in today's podcast are those of the presenters and not necessarily the Judge Advocate General's or the Department of the Army or the Department of Defense.
Court thanks counsel for both sides. The court will stand in recess until further order of the court.